This particular case, in my opinion, it could really change Facebook as we know it.
Essentially, everything you do on Facebook is infringing our patent.
What this case involves is that a court already has decided that Facebook literally infringed against 11 of 11 claims of this patent. And this patent is basically the foundation of Facebook. It's the source code. It's what runs the whole engine of Facebook. So when it's coming up into appeal here, there is significant ramifications, both financial and even operational, for Facebook going forward.
The core engine running that we invented, that Facebook is infringing, is essentially the technology that allows a user to move from their own personal space to another person's space, and the system is able to track and to identify who they are, where they are, when they're there, and all of that mechanism for how that works was our invention. My name is Mike McKibben. I'm the chairman and founder of Leader Technologies out of Columbus, Ohio. Founded Leader in '97. Our objective at that time was to build collaboration software using the emerging internet. When we started Leader, the internet probably had less than 10 million users. And I had come off a project where I had rebuilt AT&T's email system and saw a lot of opportunity with the emerging internet, but it was way too early. So we began a process of discovery to figure out how we could use this new internet technology for large-scale collaboration with security and privacy as two major design criteria. Around the year 2000, we had a magic aha moment, and we figured out what was wrong with collaboration on a large scale. We knew we had something very special, so we sought the counsel of very knowledgeable patent people in Washington, D.C., and that began a development track that led to our filing for patents at the end of 2002 for the patent we're now asserting against Facebook.
I happen to have the actual documents, the white papers, the technical white papers that Leader Technologies sent out in 2003, kind of describing, or actually describing, the major components of their invention, this source code that Facebook is running on. The CEO of Leader Technologies, Mike McKibben's son, was at Harvard in an adjacent dorm to Mark Zuckerberg. The CEO sent this via email to his son, and it was in his inbox during the night of Mark Zuckerberg's infamous hacking episode.
I'm familiar, somewhat familiar with the other cases that have been filed against Facebook and have a kind of a working knowledge of them. I'm not familiar with any other claims that go right to the core invention of Facebook. There are various trade secrets claims and other patent claims I know about, but nothing that comes close to affecting their core technology.
Well, really the reason this case came to my attention is because recently Facebook filed an S1 document, which is to sell common stock out on the marketplace. They filed this great big document, but there's no mention of this case at all in the document. No mention of potential damages that could be in the hundreds of millions. No mention that there could be an injunction that's carried through on them, similar to the BlackBerry case we had not too long ago. And that's really what started putting up all the red flags and caused me to sort of dig into this story a little bit further. Why was this not mentioned?
I saw the S1. I opened to the first page, and I was frankly shocked because the lead counsel for Facebook was our former counsel in 2002. And that happened to be the critical period that Facebook was attacking at our patent infringement trial. And Fenwick & West, who is the law firm, was privy to all of our technical information, all of our business information, all of our financial information back in 2002. And we were very surprised to see their name on that S1. The outcome of the trial was that Facebook was found guilty of infringing 11 of our 11 claims that we asserted at trial, and there was no published prior art. And Facebook prevailed on an esoteric area of law called on-sale bar, for which they had no evidence, and that we are appealing now at the Federal Circuit.
Facebook took an avenue to try to accuse Leader Technologies of false marketing their patent, which means that they were trying to say Leader Technologies didn't actually invent this software, that it was already out there, already existed in the universe somehow, and that they were just trying to claim a patent to it. But when it finally came to trial, Facebook attorneys apparently weren't able to prove that with all the material, the evidence that they gathered.
They flipped. They went exactly 180 degrees from false marking by claiming, okay, they did have a patent and they tried to sell it too early. And so that flip occurred, and then they tried to take interrogatory number 9, which was answered related to false marking of our product in 2009, and repurpose it for their use as some sort of admission that our product in 2002 also practiced the invention. So their question was, does your product in 2009 practice the invention? And we said yes. But there was no question about 2002. So the repurposing of that question is really what confused the jury, I believe.
Interrogatories are part of the discovery period. They're written responses, to questions that are given to various members of either party. And interrogatory number 9, which I refer to specifically in that blog posting, was a question that was presented to the CEO, Mike McKibben, and then presented partially. His answer was presented to the jury during the trial, but only partially. I actually have the document here where it shows that good 60% probably of the answer to the question was redacted, removed, not shown to the jury at all, erased off the record. They were trying to apply the answers to this question, which was a question based on 2009 technology, and apply it to 2002's technology, which was the period of question during this on-sale bar claim, that it was beyond, offered for sale before the patent was filed.
We didn't have any opportunity to completely do our discovery because that claim was added after discovery closed. And so essentially we had no opportunity to build our defenses in that area. We had to go to trial with whatever was there that we had built for false marking. And there was enough evidence to prove that we hadn't tried to sell it, but that's where Facebook was successful at getting the jury confused as to what that evidence meant. And the key piece of that was interrogatory number 9. So that was the foundation around which they built this whole story. One of the pieces of evidence that kills Facebook's argument on sale bar are our NDAs, which were a big subject at trial for different reasons. But our NDAs, which are non-disclosure agreements, are entered into with people that you are working with as you're building product or talking about your business plans and things like this. All of the people that we dealt with at that stage had signed NDAs, and one of the terms of our NDA is something called a no reliance clause. And that specifically says that, okay, we're going to start talking about business opportunities, but nothing that we talk about can have any legal effect. And when parties who are knowledgeable enter into such no reliance clauses, that means that nothing could be construed as an offer. So this accusation of on sale bar that we tried to offer the product for sale was negated by this prior agreement for no reliance.
There's been a lot of fervor about the Facebook IPO, and a lot of people asking who's going to benefit. How can we get involved in Facebook IPO before there is an IPO? Well, you invest in companies that are also going to benefit, one of which was Zynga. Zynga is a software company that produces the games and various things you can play on Facebook, I guess it is. One of the investors in Zynga, Digital Sky Technologies, large investor in Zynga, is also a large investor in Facebook. And after this blog story broke, you could call it a coincidence or not, but over the last couple of days, this Zynga stock has been crushed down over 15% in the 2 days following the post of this first compilation I put on the blog.
March 5th is a hearing before a 3-judge panel at the Federal Circuit in Washington, D.C. And after that, the judges will take all of the evidence and the briefs away, and we'll come to a decision on our appeal. And I've been told, I don't know, but I've been told it could take anywhere between 2 to 3 or more months for that decision.